Thank you, Caleb. Hello again to everyone. I'm sure that some of you are very interested in hearing, what's going on now that there's COVID-19. It's not like the risks to children disappear just because there's a pandemic, or it's not like criminal intent just goes away just because there is a global pandemic. And you're right to think that um, it's a perfect storm, really, when you have quarantined offenders abroad at home, not able to go anywhere or do anything. And then you also have children on lockdown in the Philippines who are locked down with their traffickers. Some of the important observations that partners have made in this very difficult season include an increase in image-based offending, 86%. That's from the Australian E-Safety Commissioner. Our partners at the Australian Federal Police and the Australia Centre to Counter Child Exploitation, and I apologize for the missing C there, they report that child sexual abuse sites were crashing due to heightened traffic, so much volume and demand that they broke the system that was supposed to be feeding the data to the users. We also see increased downloading of child sexual exploitative materials, which is CSEM. In Spain, Denmark authorities reported access attempts to such materials as well from their side. The We Protect Global Alliance has actually cautioned everyone that there's a highly probable risk that OSEC will increase. So it's against this backdrop of heightened risk and very real dangers for children that we believe the power and the good that comes out of law enforcement and prosecution becomes even more important, because this is the moment when our children need it the most. This is the moment when the Filipino children need their law enforcers, the prosecutors, social workers to step up. And we're very happy to share that our partners have indeed risen to that challenge. And we included these statistics as a sign of hope that even though the virus is prevalent and the end is not very near in sight, rescues can happen. And so there actually have been 16 instances since March 16, 2020, some of these during the enhanced community quarantine. 16 child protective rescue operations, 81 actual rescued children, and 17 convictions. So even the justice system, even the Supreme Court stepped up, if you look at it that way, that at a time when children really needed the system to be working, they found a way. And so we had 17 convictions, and a majority, I think it's around 10 convictions, involved the promulgation through video conference hearing. And so again, this webinar is about digital transformation. I mean, it is happening in different places. It is happening in the system that protects children. Of course, the sort of underlying and very important policy of the Philippines, the Philippine law, is to uphold the best interests of the child. And every single figure in that last slide is a testament that this principle is at work. 16 actual rescue operations, the 81 children that were rescued, and the very fact that courts have found a way to remain operational and to work to accord the rights of the parties that are appearing before them. That's a sign that they are upholding the best interests of the child, and of course, safeguarding the human dignity of those that appear before them. And it's just a quick reminder of the demographic we're working with and that we are interested in serving, talking about very young victims, usually 12 and below for at least 45% of cases. And complicating that, a lot of the offenders are also family members, relatives, or close adults who unfortunately are also the people that the children need for their own protection. So if you can imagine yourself in that position where the main people in your life, the main adults in your life that are supposed to protect and nurture you and look after you have now become the perpetrators, and there is a case that's been filed, an adversarial proceeding. And sometimes those proceedings can take years. one of the most dangerous portions of a survivor's journey to recovery is that zone where they're working through the court system, where there is a case filed. And so we're just going to talk to you a little bit about some of the measures that we've seen effective in protecting children that move through the court system. And we'll start with one of the most effective tools, one of the most powerful ones. Many of you may have already heard that plea agreements have been very helpful in protecting children from re-traumatization. Some of you may be aware that the Department of Justice has released an advisory that recognizes this as a helpful tool when it is appropriate. And what happens in a plea agreement or a plea bargain is the accused is actually going to admit guilt. And in return, the sentence will be lower because they're admitting guilt to a lesser but necessarily included offense. So for example, their penalty might go down from life imprisonment to 20 years or from 20 years to 15, as the case may be. And what the victim gets in return is that peace of mind that they don't have to be placed in these adult adversarial proceedings, giving testimony against a loved one, even though it's the right thing to do um, on paper. To ask that of a child is incredibly unwise. In fact, I have a dear friend who is a public prosecutor, and she has openly championed sparing children from having to be in court. And she mentions it a lot. One of the wisest things we can do is to keep children, especially children of tender age, away from the courtroom. You know, we don't want to be building cases on, on the testimony of very young children. And of course, in certain cases, pre-verbal victims would not even be able to serve as witnesses. And so plea agreements have served as a very powerful protective measure. And there have already been 103 convictions. This is a bit of an update from what Caleb shared earlier, which was in Q2 of this year. We were at about 90 that we know of. Now it's at 103. And I'm just pleased to share with you that in 83 of those cases, these were facilitated through plea agreements. And that really meant that they're sparing children from that um, difficult travail through the court system and contributing to their recovery. And we've seen courts fully aware of the power of this measure. We've even seen judges that also allow a family conference to happen after a guilty verdict is rendered, to start planting the seeds of restoration and the seeds of reform in the offenders, and of course within the families that have been fractured by this crime. The other thing we've seen very helpful is a 20-year-old tool that the Supreme Court created in the rule on examination of a child witness. And a lot of practitioners, maybe some law students here or members of the legal community are probably very familiar with that rule. And they know that you can actually preserve testimony electronically if you follow the rule correctly. And you come out with what is called a video in-depth interview. Very helpful. It's usually conducted by a multidisciplinary team or a trained law enforcer. And the value is tremendous. You can reduce the number of times a victim needs to tell their story. And again, you heard it from Ruby, how difficult it is for her to even recount it. And so sparing them that is incredibly valuable. And then you have testimony preserved in a format that is actually acknowledged by the Supreme Court as admissible and valid when the proper requirements are met. So that's been incredibly helpful. And the impact on the community has been, out of the 142 children that were actually interviewed during during the inquest proceedings right after rescue, 102 were spared from having to appear before a prosecutor who would then decide if the case should proceed to trial. At the same time, many of them also benefited from not having to appear in court in the 18 convictions that were achieved, which also had the benefit of children who had VDs, just in case a full trial was necessary. And so it's just a sense of being very cautious and careful when a child is involved, and making sure that if there is a protection available to them, our partners are able to provide that. And it's something that's not difficult to take. You just need a camera, of course, a computer to transfer the video once it's done, and you can actually give the media. Usually it's a USB drive that's given to the prosecutor, who can then view later on to verify for themselves what it is the survivor went through. So that's been very helpful. The next two we're going to share very briefly became very helpful. Well, actually, this next one is very helpful in the pandemic and actually didn't exist until COVID-19. It's one of those things that I'm amazed by. The, the DOJ and the Supreme Court both came out with measures that would allow parties to appear at inquest remotely and appear also in courts remotely. And if you've been following the issuances from the Office of the Court Administrator, first and second level courts, all of them that have the accounts and capacity, are now able to do video conferencing hearings in all proceedings at whatever stage. And so we're seeing that you can actually have a survivor right after rescue, for example, and this happened in a particular case with 7 victims, the youngest 3, the oldest 12, and each one of those victims did not have to appear before a prosecutor. Instead, they were at a safe place, joining through a Zoom conference or a Zoom call, appearing before the prosecutor, and the prosecutor was able to propound her child-friendly or child-appropriate questions through that call and go through the process with the least amount of harm to the child. They don't have to travel. They don't have to be exposed to potential, the virus that was still very much a risk for them and still is now, right? And so this remote victim appearance was a very good measure, and we are hoping that a permanent version of this can persist even after COVID-19. Finally, one thing we celebrate is that our prosecutors, our public prosecutors, have reached just a point in their ability to move cases forward where they know they can build strong cases without victim testimony. They know that there's digital evidence. They know how to present it. There are expert witnesses that they can bring to illumine the court on why there was like thousands of child sexual abuse materials found in the possession of the accused and why they can attribute ownership and intent to distribute. They also know that there's law enforcement evidence that is directly able to prove the elements of the offense, especially when the crime involves a transaction for a live show. So there are strong cases without victim testimony, and it is one of the wisest things that we can do to spare children from having to appear in court. Of course, the journey of a survivor will not end with a win in court. I mean, they might get the conviction, but the needs and the journey remain. And so we wanted to share with you just a little bit about what is necessary for a survivor to continue his or her journey of restoration. Naturally, right after rescue and in time of crisis, they need a safe place to land, a safe form of trauma-informed placement, and then they need structure and return to normalcy. They need to feel like their lives are falling back into a good kind of order where they're safe and protected. And they also need strong trauma service that caters to their need for healing. Trauma wounds exist after being exposed to OSEC, to online sexual exploitation of children, and they need services that meet them where they need them. They need it the most. And also long-term options. Very important that a survivor is surrounded by a community of care that is not going to leave them until they are healed. This is just to show you that, the court case, legal protection, and all of that, it's just one of 6 domains of restoration. There's safety, mental well-being, economic empowerment, social support, and physical well-being. And all of these are like the minimum requirements so that a survivor actually reaches a point of restoration. So very important that these exist. And of course, question some of you might be asking is it possible then, given the complexity of this journey, is it possible for them to reach a point of wholeness and restoration? And I'm happy to share the answer is yes. And we have some numbers that show the lives that have been changed and affected by good aftercare, by communities of care that come around survivors. So in Cebu, in 2018, there were 15 survivors that reached a point of restoration. But in 2019, that number jumped to 34. In Manila, in 2018, there were 4 who had reached restoration. By 2019, that number had jumped to 19. So we're sharing that as just an illustration of the hope that exists, and that it really is worth it to invest in our survivors and to journey with them, because restoration and wholeness is possible. In fact, the main goal is to reach a point in our work where deterrence and prevention of OSEC has succeeded, which is usually the result of effective law enforcement and victim or child protective prosecution. The end goal is to see less and less victims needing care and rescue, because there has been a preventive sort of effect from all of the work that the government and its partners are doing. And that is the end goal in mind. Of course, understanding the value of the one survivor and staying true with them as they journey through recovery. And as we're moving now to the part of our webinar, which I think a lot of us have been waiting for, which is, what can we do as a community? And to kind of jump off into that question, I want to read this quote again that is actually a favorite of ours. There can be no keener revelation of a society's soul than the way in which it treats its children. And so I'm going to speak to some of you right now that are part of a specific sector, fellow law practitioners and members of the academe. One of the things we believe we can do to really ensure that child protective measures stay in place past the pandemic season or era is to support long-term judicial resilience at the system and individual level, the level of like the system as a whole and the courts themselves, to really come alongside and imagine together with the system and test out solutions. We're just delighted to see that now victims can appear remotely when before that wasn't even a possibility. And it's because there was this attempt from the system to adjust. And so we urge our fellow practitioners to keep that momentum. Those of you who like to publish and write, bring out your best thinking and make it known, put it out there. Personally, our experience has been that the Supreme Court, through the Office of the Court Administrator, is very willing to receive casework data, statistics from your own experience, and use that to craft solutions. So that is an area that I hope we can move toward together. And to talk to other communities that are present on this webinar, I'm going to turn you over to Caleb for a bit. Caleb.